This is a webinar that we're running this morning around changes to employment law and practices in 2024. It's a relatively sort of fluid situation still in terms of some of the changes that are likely to be made. So these are the ones that we're kind of aware of at the moment, and include some changes that we were notified of last week. So we'll run through at the end any that we think are sort of still in motion that may be likely to come through as well. So just as introductions to start, so my name's Alison Smith. I'm the CEO and also a lead consultant at Roots HR. And I'm going to be running the session today along with my colleague Jimmy. So I'm going to quickly hand over to Jimmy so he can say hello to you as well.
So good morning, everyone. My name is Jimmy Fazanten. So I'm the service manager of our fantastic compliance service. And I'm also a consultant at Roots. And I'm very much looking forward to do the session with you all today.
Thanks, Jimmy. So Jimmy and I will be running through this webinar for you. We anticipate it will be about an hour, including time for Q&A. So questions can be raised during the session. So you'll see on the Teams function that there is a little box that says Q&A. If you click on that button, you'll be able to input your questions. The way that we're going to run the session today is at the end of each section. So when we've sort of run through that particular change with you, we'll break for some questions, so you can use the Q&A button to do those. As the webinar is being recorded, what we will do is we will pause the recording before the final Q&A of the session today. So if you want to raise any questions entirely confidentially, then I'd suggest popping them in the Q&A for that final Q&A session that we'll run through. Okay, so just quickly to introduce, in case you're not aware of us, as Roots HR, we're the UK specialist consultancy for human resources for the social sector. So we operate entirely in the social sector, so we only work with charities, social enterprises, other not-for-profit organisations. And we are actually a social enterprise ourselves. So we reinvest our trading surpluses into our social impact fund. And what we do is we use that social impact fund to be able to deliver sessions such as this and provide other free resources and training as part of our social purpose to sort of develop management knowledge and skill in the social sector. And that sits under the umbrella of our sort of Roots HR Academy. So we're absolutely delighted to be able to use that funding to provide the webinar today. And also I'll let you know that yesterday was our 15th anniversary. So we were founded in 2009. And after today's session, we'll be happy to share some offers with you that we've introduced to sort of celebrate that anniversary. So what we're going to touch on today is we're going to focus more in terms of changes to holiday pay and entitlements. Thank you, everybody, for your congratulations that are coming through. So we're going to talk about changes to holiday pay and entitlements. We're going to talk about changes to the right to request flexible working, the implementation of carers leave, some changes to the TUPE legislation, talk a bit more about what TUPE is, and more. So there's more changes that we're going to run through with you. Jimmy and myself will be going through various sections with you. So the first section around changes to holiday pay and entitlements is a section that Jimmy's going to go through with you. So I'm going to hand over presentation to Jimmy for this one.
Fantastic. Thank you, Alison. So so we're going to talk about holiday pay first, and some of the changes that are going to be introduced and some of the elements that are going to be confirmed into UK legislation, considering we now left the EU and we need to kind of tidy up a few things as a result of that. So the first thing we're going to look at is the simplification of holiday pay calculations by making rolled up holiday pay lawful again. So if you remember kind of a few years ago, holiday pay was always kind of a banned practice by HMRC, but employees were doing it because you could get away with it in a tribunal, and everyone seemed to think it was absolutely fine. And then up till like July 2022, the Supreme Court ruled that that was no longer an acceptable practice. And if you remember, if you have this kind of irregular hour workers, or you have kind of term time only workers, you would know that you had to start kind of going through this kind of complicated calculation of annual leave and how you had to apply that to those hours that they worked. So we're going to have a look at in more detail what that actually means, what are the changes, what can you do, how do you calculate that rolled up pay, and then also how do you pay that rolled up pay, which is quite important. And what's more important even is when you can start doing that, because it'll be different for different employers depending on when your leave year starts. Also, the legislation is restating some various pieces of retained EU case law. So obviously, as I said, we left the EU as a result of Brexit, and there was some kind of EU case law legislation that was kind of coming out of Europe, but not necessarily defined within UK legislation. So to kind of create clarity, the government has introduced some definitions of how you apply, for example, carryover leave. And so one of the biggest changes that we look at is, for example, where people are on family-related leave, so like maternity leave or adoption leave, and they cannot take their annual leave as a result, they're allowed to carry over 4 weeks annual leave. There was always an understanding you would do that anyway from a discrimination point of view, but now it's confirmed in legislation that they're allowed to carry over 4 weeks. We would still recommend, of course, that you talk to your employee, you try to plan annual leave as much as possible so they don't take all their leave to the following leave year. But from a statutory point of view, they're allowed to take 4 weeks over to the following year. Similarly, if someone is on long-term sick leave, again, they can take over 4 weeks leave to the following year before a maximum of 18 months from the year that they accrued that leave. So again, it's a bit of a shorter period, but it allows them again to carry over 4 weeks leave if they couldn't take those leave because they were on long-term sick leave. And then finally, people are allowed to carry over 4 weeks if, for example, their worker was not given the opportunity to take annual leave in a given leave year. You shouldn't be doing that. You should be encouraging your employees to take leave and give them the opportunity to do so. But if there was a moment where you didn't give them the opportunity, for example, you blocked a few of their requests and then they couldn't take annual leave elsewhere for whatever reason, they're allowed to take over that 4 weeks to the next year. Or where the employer has failed to inform the employee that if they did not take all their annual leave in a certain leave year, that they would lose that leave as a result. If they were not informed of that, then again, employers have the right to have their annual leave carried over to the following leave year. That's 4 weeks of their leave year being carried over to the following leave year. Now again, and this will be quite hopefully known to everyone already, but as an employer, you should encourage your employees to take annual leave in a given leave year, and you should ensure they have the opportunity to do so. And we always recommend that you remind employees if they have loads of outstanding leave, say in the last 6 months of their leave year, just to make sure that you've done everything you did to remind the employee of their leave entitlement and to give them the opportunity to take that as well. So that's about carrying over. That's a piece of legislation coming from the EU now being defined in UK legislation. And then finally, this is a British case law element, but it's now again part of legislation, and that's about defining normal remuneration for the purposes of holiday pay to include commission payments, bonus payments, and overtime payments as well. And I want to cover that in our next slide. So holiday pay has always been a bit of an interesting one about how you calculate that, and where you are an employee who only pays normal kind of salary, and that's for the vast majority of employers, where you don't have any bonus or regular overtime or commission, it's very straightforward, right? You pay the 5.6 weeks at their salary, and everyone's happy. But where you are also paying regular commissions or overtime or bonus payments, then we need to start thinking about how we need to compensate for their pay when they're on annual leave. And it's divided in 2 sections. So we have a 4-week section, which is the statutory annual leave. That's kind of a little thing that came out of the EU many years ago. And then the 1.6 weeks, which was introduced by the British government back in 2009, I believe it was, which was kind of an addition to what the EU required as a minimum. And so UK workers since 2009 had this kind of entitlement of 5.6 weeks leave. But we kind of kept the 2 separate throughout legislation all the time. And that remains the same as we go forward. But what that means is that we have potential different rules to those different sections. And so when we look at pay, we look at the first 4 weeks of that annual leave. What does that actually look like in terms of how we need to apply pay? And the legislation now says we need to apply the normal rate of pay. And what that means is we have to include things like regular overtime, regular bonus payments that are linked to that performance, and regular commission payments that they might receive as a result of doing something. In most of our cases is linked maybe to fundraising, for example. And so when they go on annual leave, we need to make sure that they're not disproportionately affected by that because they're away from leave and therefore they can't work overtime or they can't do work that would result in a certain bonus. And so the government is now saying, well, for those 4 weeks, you need to ensure you apply those bonus payments as if they would have worked. And we look at the average normal working pay, normal rate of pay in a given period. So what would that pay include? Well, we have payments including commission payments that are intrinsically linked to the performance of tasks which a worker is contractually obliged to carry out. It could be payments related to professional or personal status, relating to the length of service or seniority or professional qualifications. So that often kind of is towards like acting up pay, for example. And then other payments as overtime payments which have been regularly paid to a worker in the 52 weeks preceding the calculation date. So we look at it over a period of 52 weeks and say, okay, well, what was the average pay if they received, for example, overtime payments? And that's the pay we apply. And that's kind of to help the employers avoid a situation where an employee thinks, okay, I've got 3 weeks annual leave coming up in August. I'm going to do some overtime in the last 2 months before that, and then hopefully get some extra pay in August as well while I'm on annual leave for most of that. It doesn't work that way. Obviously, it's a period of 52 weeks we look at and say, okay, how regular was that? And the test sometimes is, well, is it reasonable for an employee to expect that level of pay, considering all the extra payments they've been receiving over all the other weeks? That's kind of the 4 weeks. And then with the remaining 1.6 weeks. Now, for most employers, the 1.6 weeks for a full-time employee, it is equivalent to 8 days. And it usually applies to bank holidays because most employers are closed on bank holidays. And so again, it's quite easy to keep the two very separate. But bank holidays are not defined within the legislation as a statutory right. The statutory right is 5.6 weeks leave. So what their government has said, well, we'll keep the 1.6 weeks still separate. And actually what we're going to do is we're only applying the basic rate of pay to those 1.6 weeks. So in other words, you don't have to worry about bonus payments or overtime or any of that you need to take into account when you calculate the normal rate of pay. You just look at the salary and what's contractually agreed as a pay for that particular employee. So that's for the remaining 1.6 weeks. As I said, for most employers, that applies to the bank holidays, and so it's quite easy to keep the two things separate. But of course, if that's not the case in UK, maybe you're a shop and you're open 7 days a week, and so people have to work bank holidays, then you need to work that out manually on keeping that those two elements separate. So that's on holiday pay, and as I said, we can always kind of answer questions because it's never been fully straightforward up till now, but hopefully the legislation is kind of sorting out to a certain degree. I'm going to take a little sip of water. So this is the big one, because back in July 2022, the Supreme Court ruled that people who were, and it was a case specifically around term time only worker, who claimed he was entitled to 5.6 weeks leave, just the same as someone who works a full year. And the Supreme Court ruled and looked at the legislation and said, actually, we haven't made a distinction between the two. And so a worker is entitled to 5.6 weeks leave. And so they ruled that this term time employee who only worked 40 weeks a year, I think it was entitled to the same amount of annual leave from a statutory point of view as a person who works the full year. And by extension, they also applied that to casual workers or 0-hour workers who worked irregular hours. And what that meant was that you ended up in this weird scenario where employees, workers who maybe worked every 2 weeks or 3 weeks in the year could technically still be entitled to 5.6 weeks leave if that contract continued throughout the whole year. And of course, that was a very strange situation. Now, we had 3 prime ministers since, but they have fixed it. And we now have a legislation that says, well, actually, we realized that didn't make much sense. And we looked at how could we make this more proportional to the actual hours or weeks worked in a given year. And so they've now said that rolled up pay is allowed. And what that means essentially is you can apply a percentage to the salary earned by that particular individual in a given pay period to work out what the holiday entitlement is, and then pay that in cash, or the way you pay your normal employee through payroll. You pay them directly the holiday pay entitlement. And of course, that's a much cleaner way of doing it. It's a lot less administrative heavy. And the employee will get, proportionally speaking, the exact right amount of what they were entitled to. Now, it should be absolutely clear that 12.07% is the statutory minimum. Of course, you can go over that if you want to, but 12.07% is the minimum amount of pay that an employee is entitled to if they are going to be, if this is going to be applied to them. And again, this can be applied to people who are working on irregular hours, who are casual workers, agency workers, or those who are on term time contracts. In fact, if you looked at the contract before, a lot of teachers who were term time only always had 12.07% in that contract. That's quite a standard clause for the annual leave. So employees now can actually use the 12.07% calculation, and we're going to have a little look actually what that means in terms of the calculation. But what's quite important here to understand is that on the normal rate of pay. So again, if you think about the normal rate of pay that we talked in the previous slide, that includes the additional payments that you might make on a regular basis. Now, overtime might not be necessarily something that applies to casual workers, because the whole point is that their hours fluctuate. But for example, it could apply to term time workers who might do additional hours in term time. And if that happens on a regular basis, then you need to think about that in the annual leave calculation. Similarly, if, for example, casual workers are given commission payments over a particular fundraising target, then again, if that's a regular thing, you need to keep that in mind when you start applying this percentage. And the final thing to know about this before we look at a calculation example is that it only applies for annual leave years starting from the 1st of April 2024. So although the legislation came into place 17 days ago and actually is in force now, it does not kick in until leave years starting from the 1st of April 2024. So if your leave year starts on the 1st of January, then you cannot use this method until the 1st of January 2025. And that's quite key to remember. It's a bit of a confusing thing that the government has done, but I'm guessing they've done it for a bit of a grace period. But if your leave year starts on the 1st of April 2024 after that, then you can start applying this from the 1st of April or whenever your leave year starts after that. If your leave year starts on the 1st of January, February or March, then you have to wait till 2025 before you can actually move to this roll-up pay method. So let's have a look at an example calculation so we can see what that actually looks like in terms of applying this. So the example that we're given is Hannah, who works irregular hours and is paid weekly. Priority rate is £10.42 per hour for all the shifts. In the week from the 1st of October to the 7th of October, she works 35 hours. Now, in order to work out how much pay, holiday pay she's entitled to, the roll-up pay, we need to apply 12.07% to her pay in the given pay period. So we know that she worked 35 hours in that pay period because it's 1 week. At a rate of 10.42, so we know that's £364.70 in total. That's her pay. That's her normal rate of pay. There's no bonus payments in this, no overtime, no commission. She only gets the normal rate of pay or a basic rate of pay, which is also her normal rate of pay in this case. Now, in order to get to the 1%, we divide it by 100. That gives us 1% of her total pay, which is £3.65. And we know that we have to multiply by 12.07 because that's the percentage for the statutory annual leave entitlement, which gives us a total of £44.0555. Now, we'll always round up to make sure that they get at least the minimum statutory. If we round down, we fail to comply with the statutory legislation. So we round up and that gives us a grand total of £44.06 as roll-up pay in her annual as an annual leave entitlement. And the way you would work this out on the payslip is you're going to have 2 lines of pay. One that shows the normal rate of pay, whatever she got paid that pay period, in this case the weekly pay period of £364.70, and then the second line that very clearly states that this is the holiday pay that she's receiving at £44.06. So they need to be itemized separately on the pay slip. Now, I expect that at some point all the payroll systems will update and have that particular feature given to them. Until then, it probably is an Excel spreadsheet exercise. But the important thing is that you keep the two lines separate so that if it ever gets challenged, it's very easy for you to point out what the holiday pay was in relation to the actual pay. So that's the example. So we'll look at what to do next now, because of course you want to get ready for this. Obviously, if you've got till next year, you've got quite a bit of a period to prepare yourself for this. But if you want to apply on the 1st of April 2024, and that's when you leave your starts, then you can start thinking about how to apply this to those contracts. Now, chances are, because we had it for 18 months where we had to apply this 52-week reference period and then work out every weekly pay and then work it out every time someone took leave, the contracts may actually state that that's the method you're going to use to calculate annual leave. So in order to change that, if you want to change it and you want to change the roll-up pay, then you have to consult with the employees and make sure they understand the change you're about to make and the implications of that. In my experience, most employees before this ruling existed were quite happy to accept it because it means more pay in their monthly pay. Overall, it should work out roughly the same. But employees tend to be quite happy with it, but you need to consult with the employees. You need to make sure they understand, address any concerns that they might have before you make the change to their contract. Roll-up holiday should be paid at the same time as the worker is paid. So always look at the pay period. If it's weekly, then you have to pay it weekly and calculate it weekly. If it's monthly, then you calculate it monthly and pay it monthly. That's quite important. You can't just do, say, over a period of quarters that you pay the roll-up pay. It has to be done at the same time as you pay the employee. And as I said earlier, it needs to be clearly itemized on each payslip. In other words, it needs to be a separate line on the payslip that very clearly states that that particular amount of pay refers to the rolled-up pay that they are receiving and entitled to. So that's the next steps. As I said, if you're going to do in April, you've got a few months. And always make sure that whenever you do consultation, you want to make sure it's meaningful. So give the employees enough time to ask the questions and raise concerns. If you've got till next year, there's no harm starting that process. But you've got a bit more time to prepare yourself for that. So that's on annual leave. Any questions?
Well done, Jimmy. Do we have any questions, Charlotte, on annual leave at the moment?
Yes, so I'm just having a look now, and we've got, so does this apply to part-time workers too?
No. It's only sort of part year, which would be term time, or irregular hours. So that's more your sort of casual workers, 0 hours workers. So no, not part-time.
Thank you, Alison. And is there a definition of what is regular when considering regular payments?
Well, I mean, the test that I always understood they apply is, would it be reasonable for the employee to expect that payment in the pay package? And that, to a certain degree, is a bit of a contextual subjective, but again, you look at over a period of 52 weeks, that's the way I would do it, and say, okay, well, how often were you applying that pay to that particular individual? And you have to make an assessment on whether that was regular or not. I would say it's, well, if you consider that to be regular, then you apply that pay. Of course, the employee might challenge that if you say that I don't think the payment was regular, and then you might have to review it and potentially get someone independent to look at it as well, just to get a second opinion on that. But I don't think the legislation, I'm looking at Alison as well, but I don't think the legislation actually defined what regular means.
No, it's always unhelpful in that those definitions of regular or reasonable are never clearly defined. But yeah, I agree with Jimmy. The key thing is, would that employee expect to have that payment in that pay packet on a regular basis? So are they doing overtime every week or every month? And I think it's about looking back over that 52-week period and seeing how regular that was.
Thank you. Are you going to be talking about what's regular for bonuses? Do you mean regular as in monthly, weekly, or do you mean a one-off annual performance bonus?
Well, an annual performance bonus would not be regular, because that's a one-off every year, and they would get that outside the holiday pay anyway. That's just normally a payment that you make in addition to whatever pay they're already receiving. But really what we're talking about is if, for example, every week they have to hit targets, and as a result of hitting that targets, they get a bonus as a result of that. So it's directly linked to that performance. That's the kind of regularity that we look at. And of course, they might not get a bonus every week if they don't hit targets, but the bonus structure is there that if they hit the targets every week, that they will get that additional pay. And if they hit that regularly, then that would be considered regular.
Mm.
Thank you. There's quite a few questions coming in, so I'll just move on to the next one. Can we start this before April 2024?
No.
No.
Is there an example you could share of how to calculate holiday pay to include overtime?
Possibly, but there are some examples on the gov.uk website. So I would signpost you to the gov.uk website. They have a number of different scenarios and examples of calculations. So I'd signpost you there in the first instance.
Thank you. And if someone's paid for different pieces of work in a month, do you just total up the value and then multiply by 12.07%?
Yeah, I mean, it's over the total pay. So whatever salary they get in that month, that is that normal pay, normal rate of pay, that's the percentage applied. So if they do, I don't know, 5 different pieces of work in a month, then whatever pay they get for, and the pay period is a month. That's a quite key thing, isn't it?
Mm.
Then it's the whatever pay they receive in that month, you calculate 12.07 over to work out how much the annual leave entitlement is.
Thank you. So someone's holiday year is to the 31st of December. Can we change over sooner by calculating a part year annual leave entitlement?
No. No, it's clear in the legislation. The legislation actually states that this relates to annual leave years that begin on or after the 1st of April 2024. So no, unless you consulted with staff to change your annual leave year to start with effect from 1st of April, then no.
Thank you. And I can see that there's a couple of hands raised at the moment, but if any questions could be added to either the Q&A section or the chat section, we'll be able to go through those.
Brilliant. Thanks, Charlotte. We'll move on, and then, as I say, there is not a further opportunity for questions that we can pick up any further questions in the sort of the final Q&A of the session. Okay, so we're going to move on and just quickly talk about TUPE here. The reason we're moving to TUPE is it's included in the same piece of legislation that has been used to introduce those changes to holiday. Now, when we talk about TUPE, TUPE is the Transfer of Undertakings Protection of Employment legislation. And it applies to basically protect employees' interests in 2 particular situations. The first is where there's a sale or a business transfer. So typically where an organisation or a part of an organisation transfers to a new owner. So typically that might be where a business is sold. But the second situation is what's known as a service provision change. And that's typically where an organisation might engage a contractor to do work on its behalf. So this type of service provision change is TUPE transfer is quite common in the social sector, because we might have commissioners such as local authorities who are seeking to contract service delivery in a particular area, for example, community health and lifestyle programs, and they may be looking for an organisation to deliver that service on their behalf. Now, that can be known as a service provision change if there is then a move of service delivery from one provider to another, or back in-house into the local authority. And TUPE exists to basically protect employees' interests in the fact that the new employer typically steps into the shoes of the old employer. So the sort of the ongoing protection of employment, as is referred to in the legislation. It's a relatively complex piece of legislation, and we would always say if you are going through any TUPE transfers or potentially going through a TUPE transfer, seek professional advice to make sure that you're following the legislation. But there are some changes that this Employment Rights Amendment, Revocation and Transitional Provision regulations have brought in. It's not the larger scale changes we were anticipating for TUPE, but essentially it's a change around obligations that employers have in terms of informing and consulting with affected employees about the proposed transfer to a new employer. Currently, the obligations on employers are to consult with sort of elected representatives of the employees. So that would usually be if there's a recognised trade union with the trade unions and or any elected employee representatives. So if you're looking at a relatively small transfer of a relatively small number of employees, that can be quite an onerous task to have to elect and then consult with elected representatives. So the change that they're bringing in is that organisations will now have fewer obligations to arrange for that election of elected representatives. So specifically where the employer has less than 50 employees within their organisation as a whole, or where the transfer is proposed to affect less than 10 employees, you will no longer be obliged to consult with elected representatives, and instead you'll be able to inform and consult with the employees directly. So if you've got that smaller number, you can just do that individual or direct consultation with the affected staff. You don't have to consult sort of collectively or through any sort of elected representatives. So that makes that process slightly less onerous potentially. And obviously, informing and consulting the obligations exist with both employers, the outgoing employer and the incoming employer. But now you should be able to consult with those employees directly if you as an organisation have less than 50 employees, or where the transfer affects or is proposed to affect less than 10 employees. Now, the legislation has already come into force. It came into force, as Jimmy said, 17 days ago. But actually, this change is effective only for TUPE transfers that happen on or after the 1st of July 2024, and where there are no existing employee representatives already in place. So if you're currently going through a process and you have a TUPE transfer where the transfer is going to happen before the 1st of July 2024, then you'll need to carry on with the existing arrangements to consult through elected representatives. But if that change occurs on or after the 1st of July, then these new obligations arise. So that's the change that's happening in regard to TUPE transfers. So that's a relatively small change, but it does make the process slightly less onerous. So are there any sort of questions around that at all before we move on? I'm anticipating there possibly won't be, given it's relatively straightforward, but have we got any questions, Charlotte?
No, there's no questions.
Okay, perfect. We will move on then, and I'm going to talk to you about flexible working and the changes that are coming into place in regards to flexible working. So what's changing in regard to flexible working? Well, the big change is that it is going to be a request that an individual can make or has the right to make from day one of their employment with you. Now, that actually needed a second piece of legislation, which was confirmed again in December, or it could have been this month. I can't rightly remember, but they do have the right to request from day one of employment. So at the moment, or prior to this legislation, they had to have 26 weeks service with you. When an employee makes a request for flexible working, they will no longer have to explain in their application for flexible working what impact they think the request will have on you as the employer and how any such effect should be dealt with. So currently that's an obligation on the employee to set that out in their request. That will no longer be anything that they have to do. Employers will have 2 months to deal with the request for flexible working. Previously, the time frame has been 3 months. that will now be shortened to a 2-month period, and that includes effectively from the date that you receive the request right the way through to having dealt with any appeal process should a request have to not be accepted by an organisation. So a shorter time period. If, as an employer, you're considering refusing a request for flexible working, and there are still 8 statutory reasons why an employer can refuse a request for flexible working, you will have to consult with the employee first. So you will have to have a meeting with them first to explain why you may not be able to accept the request for flexible working. And another change is that an employee will now be able to make 2 requests for flexible working within a 12-month period. Previously, that was 1 request within a 12-month period. So they'll now be able to effectively make 2 requests within a 12-month period. Now, these changes come into place for any flexible working request which is made on or after the 6th of April 2024. So at the moment, if you've received a flexible working request or you receive one up until the 5th of April, they will be dealt with through the previous process. But for any requests that are made on or after the 6th of April 2024, it will be this process that's followed. In terms of the sort of what next to do, thinking about yourselves as employers, have a look at guidance. There is guidance that's available on flexible working through ACAS. Check to see, obviously, if you have a policy in place to handle requests for flexible working. Lots of organisations do have one. Then that will need to be updated to reflect the new process. And we'll tell you at the end actually that we actually currently have an offer on at the moment for reviewing and updating or producing flexible working policies that meet this new legislation. So review and update any existing policy that you might have in place, any supporting documentation that you have in place, and also ensure obviously that your managers are aware of changes because they may be the ones that are initially receiving those requests for flexible working. Any queries or any concerns, and obviously we would always say seek professional advice, and obviously that can be done through us ourselves, and at the end we'll run through how you can get further support from us on a free or a sort of paid for basis. So really important that you check through any policy or process that you have, update that to reflect the changes, and make sure that your managers are aware of that. Any questions on that at all, Charlotte?
Yes, so we've got a couple. So regarding the no longer having to explain the impact, whilst the statute no longer requires it, can the employer still ask for this?
I think you could probably still ask for it, but the individual would be under no obligation to provide you with an answer. So you couldn't force them to provide you with an answer in order to deal with their request.
Thank you. And regarding the requirement to consult, could this be done as part of the flexible working meeting, or would this be a separate one?
Yeah, no, it would be part of a flexible working meeting. Yeah, just means that prior to refusing any request, you would be obliged to meet and discuss the initial request. And I guess what it's trying to do is push employers more towards seeking some form of compromise or alternate solution before outright refusals. Okay.
There's a couple more. So is there a definition of what flexible working means?
I'm not sure that there's actually a legal definition, but there's certainly guidance, and particularly the guidance through ACAS. Typically, it will mean somebody looking to perhaps request a change of working hours, location, compressed hours. There's a whole sort of range, but I would suggest that the guidance on ACAS will kind of give you clarity in terms of that.
And in what circumstances can you refuse flexible working?
There are 8 statutory reasons why you can refuse flexible working requests. Again, those will be on through the ACAS guidance. You'll find those, or they're on the gov.uk website. So there's no changes to those. They remain as is.
Thank you. And just one more that's come through. Though the staff member doesn't have to say about the impact of business, can the employer talk about this in relation to their request?
Absolutely, yeah, that would be part of the flexible working meetings to talk about that, and obviously that would need to be a key consideration for an organisation as to whether they were able to accept a request, suggest an alternative compromise, or refuse a request.
Thank you. That's all the questions for that section.
Brilliant. We will move on now to talk on carers leave, and this is a new piece of legislation that's been introduced. So it's a new entitlement for employees, and what's been implemented is to give carers the right to 1 week's unpaid carers leave in a 12-month period. It's another day one employment right, so an individual doesn't have to have a length of service to request unpaid carers leave. And the right applies to employees who have a dependent with a long-term care need. It doesn't specify, I don't think it specifies what a dependent is, but it's somebody who has a long-term care need, and the individual, so the employee, would want to be absent from work to either provide or arrange care for that particular dependent. And requests can be made for half days or full days, and they can be either consecutive half days or full days, or non-consecutive. So in essence, as it's up to a week's unpaid leave, then technically that could be, say, 10 half days of unpaid leave throughout the year. The individual obviously has to give notice in writing that they would want to take carers leave, and they would have to give at least twice the amount of notice than the period of leave they're requesting. So for, or if it's longer, 3 days notice. So if they were asking for a day's carers leave, they would have to give at least sort of 2 days notice of that. There are situations where employers can postpone a request. So if it would have significant disruption on the business, then the employer could postpone the request for leave, and they could then suggest an alternate date in which it could be taken. That must be within 1 month of the original date requested. And obviously that seeking to reschedule the leave should be done in discussion or consultation with the individual employee themselves. And the employees who request carers leave, they're, through the legislation, protected from any detriment or dismissal, in particular because they either take or they ask to take carers leave, or the employer believes that they're likely to ask or seek to take carers leave. So it's up to 1 week's unpaid leave in a 12-month period for an employee who has a dependent with a long-term care need, and where they need to be absent from work to either provide care or to arrange care for that individual. Those requests can be for half days or full days, consecutive or non-consecutive. The employee has to give notice in writing of their intention to take carers leave, and employers can postpone that request if it's going to be unduly disruptive on their business. But in postponing, they have to be able to give the individual another date to be able to take that leave within 1 month of the date that was originally requested. And the entitlement to this statutory leave comes into effect from the 6th of April 2024. So in terms of consideration, you'll need to think about, do you need any policy or guidance or supporting documentation that you might need to be able to manage requests for carers leave? You'll need to consider how you record periods of carers leave, and how obviously you deal with the payroll aspects of the unpaid leave. And you'll need to ensure that managers are aware of what is being implemented, and the fact that employees from day one of their employment with you after the 6th of April 2024 will have the right to request unpaid carers leave. So again, at the end of this session, we'll run through how you can contact us for any further advice on those. Any questions in regard to carers leave?
Yes. So does the employee have to declare that they are a carer within the scope of their employment?
No, not within the scope of their employment, no.
Is that a week pro rata to hours they work per week, or is it 5 working days regardless?
It's a week, so that's a good question, actually. I would expect it to be pro rata, but we'll double check and clarify that.
Thank you. Does the carers leave provision apply when arranging care for elderly parents?
Yeah, if they're a dependent and they need care, then yes, that would be applicable.
And then there's is this in a 12-month period? Please clarify. And I think you've said that.
Yeah, it is. It's up to 1 week's unpaid leave in a 12-month period.
Thank you. That's the end of the questions.
Great, fabulous. I'm going to hand over to Jimmy again now, just to go through some other things that we're aware of.
Yeah, fantastic. So there are a few more things changing in the coming months. Some of them are expected, some of them are kind of known. So we're just going to go through those in this slide. So national minimum wage is going to increase. Now that might not be a surprise because it happens every year. But the big change happening this year is that the bracket of 21 and 22 is going to disappear. And the national living wage, which is kind of the top band of the national minimum wage, is going to be applied to all employees aged 21 and over. And that's going to be quite a big change, because for those who are aged 21 and 22 right now, they're going to see quite a nice pay rise from April onwards, considering they're moving from their old pay bracket to the kind of top bracket, which is also going to see an increase as well. So you just need to be aware of, if you have employees in that age range, they're going to be receiving a much higher pay from the 6th of April, or from the 1st of April going forwards. Just to kind of quickly go over the rates, and obviously they're on the government website as well. But for those aged 21 and over from the 1st of April, they will earn £11.44 per hour. For those aged 18 to 20, it's £8.60 per hour. Those aged 16 and 17, it's £6.40 an hour. And those who are apprentices, of course, there are specific rules around that, but those who are apprentices are also at £6.40 an hour. As I said, the increase is not a surprise. It happens every year. The big change is that the each bracket of 21, 22 is disappearing altogether. From the 6th of April, we also see an extension of protection against redundancy for pregnant employees and new parents. Now, this is quite a big change. Obviously, we're all aware that employees who are on maternity leave or who are pregnant are already having these protections, and what that actually means is they have priority over any alternative employment if available when going through a redundancy process. But there are some specific new rules that have been introduced to extend that out after a period of maternity leave as well. And so I was going to have a look at that because they're slightly different for each section. So for maternity, for people who are on maternity leave, the protected period will cover pregnancy alongside 18 months from the first day of the estimated week of childbirth. So once we know what the childbirth date is, we then count 18 months from that, which means that usually when they take a 12-month maternity period, then they also have still 6 months after that. Some people start the maternity period a little bit earlier, so they might come back a bit earlier, which means they have a bit more than 6 months once they're back from maternity leave. I should probably add to that as well that a lot of people who are on maternity leave, at the end, they usually take some annual leave. The actual kind of period doesn't really matter. It starts counting from the childbirth, from the week when, or from the day that the child was born. So that's when you start counting the 18 months. Whether it's annual leave and extended maternity periods, I've seen that as well, where it goes into 60 weeks. That does not affect this protection. For adoption, the protected period will cover 18 months from the placement for adoption, so from the date that the child was placed with the parents. And for shared parental leave, which is not one that's used very often, and it's complicated in itself, we added a different complication to that. in that this provision is slightly different. You need to hit a particular mark there before it applies to you, where the protected period will cover 18 months from the birth, so from the date that the child was born, provided the parent has taken a period of at least 6 consecutive weeks of shared parental leave. So they need to take at least 6 consecutive weeks of shared parental leave before they become eligible to this protection, which means that both partners in the relationship, both parents, can benefit from that, provided they both at least had those 6 weeks shared parental leave. Now, usually the person who's on maternity leave or the primary adopter will have that protection anyway. So it's the secondary parent that needs to have those 6 weeks at least in order to apply to be eligible for that protection. So that's very important. Now, the extension to the protected period to cover pregnancy applies when the employer is informed of the pregnancy on or after the 6th of April 2024. The extended protected periods to cover a period of time after leave has been taken will apply to any maternity and adoption leave ending on or after the 6th of April 2024. And this will also apply to any shared parental leave starting on or after the 6th of April 2024. So that's when it all comes into effect. Now, while we're at the topic of family leave, we're also going to see changes to paternity leave. And what we're seeing is some kind of favourable changes to that leave. Whereas we know at the moment, paternity leave is 2 weeks at statutory rate, and it has to be taken either as 1 week or 2 consecutive weeks. And it needs to be taken within a 56-day period, in other words, within 8 weeks. So that is changing because we're going to see a lot more kind of a favourable approach to this. So now those on paternity leave can take 2 weeks, and they can be separate weeks, so they can be 1 blocks. They still need to be in a 1 week block, but they can be 2 separate 1 week blocks taken at different times within the period. And that period that they can take now is 52 weeks from the date of the birth. So rather than 56 days, they can now take it within a 52-week period. And again, they can take 1 week whenever. They can take 1 week after birth and maybe 1 week a week before the birthday, for example. That's absolutely possible now. And employees will only need to give 28 days notice of their intention to take paternity leave, which is reduced from the current situation, which says basically that an employee needs to give you notice by the 15th week before the expected week of childbirth. So that is changing, and it makes it a lot more flexible again, because employees can then be, more supportive to the partner in bringing up the child whenever they need that. They still, as I said, need to give that 28 days notice as a minimum from a statutory point of view. And again, this will come into effect from the 6th of April 2024. Also, what happening this year is from October 2024, employees must demonstrate that they take reasonable steps to prevent sexual harassment of their employees. Failure to do that, employment tribunals will have the power to uplift sexual harassment compensation by up to 25% when an employee is found to have breached the new duty to prevent sexual harassment. So in other words, employers need to be seen to be very proactive in this. That includes making sure that your policies are up to date, making sure that you train staff, make sure that you are ensuring that there are no employees put at risk of sexual harassment, and that may mean putting some safeguarding kind of protocols into place to ensure that maybe employees are not left alone in a particular room where they're at a higher risk than normal. So you need to kind of look at your current policies and procedures and make sure that it's absolutely clear what measures you've taken to prevent this as much as possible, and also how you educate your staff to ensure they understand what actually is defined by sexual harassment. So that comes in from the first from October 2024, and we just need to be aware of that. I'm sure most employers are already doing this. The added additional pressure here is, of course, is that 25% uplift for employees who fail to take reasonable steps to prevent that from happening in the first place. Also expected in 2024 is parents whose newborn is admitted to neonatal care. They'll now be entitled to 12 weeks additional paid leave. So where a person on maternity leave has given birth, that was they're entitled to 52 weeks leave, they're entitled to 39 weeks statutory maternity pay. But if the child is then admitted to neonatal care, they get an additional 12 weeks of paid leave, and again it will be at the statutory rate and be very likely at the same rate as maternity pay. So that's happening as well. And so just need to be aware that actually what could happen in that case, because of course you don't know until the child is born, an employee will give you notice of maternity leave. They go away 52 weeks. You, of course, have an expected return date, and that date might be extended by 12 further weeks if the child is admitted to neonatal care. So we just need to be aware in our planning of that. The other thing that might be introduced in 2024, or at least we expect in 2024, is the irregular hour workers have the right to request a predictable working pattern. This is a bit of a question mark to everyone, I think, because the whole point of regular hours is that there is no regular predictable working pattern, but it's still being worked out. And I'm sure once we have the details of what that would actually look like, we'll push it on our website. We'll send newsletters if you are on the newsletter mailing list. If not, please sign up. It's absolutely useful to do that. But yeah, once we have more information, we will inform you if you're on that newsletter that what that would look like and what you need to do in order to prepare for that. But it looks like employees, so workers at least have the right to say, hey, I want a bit more of a predictable working pattern in my in my hours. But so we are quite unsure what that would look like in practice, considering that the whole idea of regular working hours is that, well, it's irregular. And still build stage, so there's not many details on this yet, but we're expecting this to at some point happen. It might happen late 2024 or somewhere in 2025. But job holders aged between 18 and 22 will be automatically enrolled in the pension schemes regardless of their earnings. And of course, that's to kind of motivate young people to actually get into the pension scheme, where they often are not earning enough money to actually be eligible in the first place. So this is going to be kind of enforcing that and getting young people onto the pension schemes and start saving for their retirement, which is a very positive change. But of course, again, as employees, you need to be aware of that because there's a financial implication in that employees need to pay 3% to the pension payments. I think that's the what else, but I think the next bit is now questions. And of course, questions on this, but also any questions you wanted to ask from earlier sections that you didn't get to ask at the time. Thank you.
Wow. Thanks, Jimmy. So just before we take those final questions, as I say, do connect with us and keep your eyes peeled for sort of very special offers that we'll have coming through as a result of our 15-year anniversary. I also want to just clarify through that session I have checked in regards to carers leave, and it is pro rata for part-time employees. So just to answer that question.